Hello. Before you proceed to watch this video, I recommend you watch my short video, Quick Primer, Canadian Legal Precedents and What the R Means, to help you understand the premise of a legal precedent if you are at all unclear. Also, watch the other cases highlighted in this series to get the big picture of the injustices happening in our criminal courts. R versus DD, 2000, Supreme Court of Canada. This is a case that set a precedent made possible only after the removal of two key statutes in our criminal code in the mid-1980s. The removal of the statute of limitations for sexual offenses and the removal of the unsworn evidence of a child provision. The unsworn evidence of a child provision required material corroboration. I discuss these changes in part 2 of my series, Evolution of Feminist Theory, Moral Panic, and the Law. The R versus DD case exacerbates the problem of the innocent accused finding himself without a defense in a court of law, and vulnerable to unjust prosecution and wrongful conviction. This case is frequently cited in both adult and child cases of alleged sexual offenses. The merits of this particular case were based on a rather dubious complaint by a 10-year-old child. The prosecution's case is that the accused, who was living with the complainant's mother, sexually assaulted the complainant by making her touch his penis on numerous occasions in 1991 and 1992 when she was 5 to 6 years old. The complainant told no one about these events for 2.5 years. In January 1995, the complainant had a conversation with a school friend about gross things, some of which were true and some of which were false. During the conversation, the complainant told her friend about the assaults. The friend reported the complainant's disclosure to a teacher, and then the matter was referred to the Children's Aid Society. A society worker interviewed the complainant in the presence of a police officer. The complainant first said that she could not remember any sexual touching, but then later revealed incidents involving the accused. The accused categorically denies the allegations. Now, at the time of this trial, there was no doctrine of recent complaint as a principle of law until 2000 with R versus DD. The most common paragraph cited from this case, cited in other cases since 2000, reads this: "A trial judge should recognize and so instruct a jury that there is no inviolable rule on how people who are the victims of trauma like sexual assault will behave. Some will make an immediate complaint, some will delay in disclosing the abuse, while some will never disclose the abuse. Reasons for delay are many and at least include embarrassment, fear, guilt, or a lack of understanding and knowledge. Of course, they do not afford the possibility that it could have been influenced by an outside party. Many defense attorneys with integrity would agree that this is ultimately the nail in the coffin for what used to exist as a simple safeguard against false accusations by adults and influenced children where no material proof of a crime exists. In my opinion, the merits of this particular case are dubious not only because of the delay in disclosure, but because of the chain of communication that took place between the complainant, her school friend, the teacher, the Children's Aid Society worker, and the investigating police officer that obviously taints the credibility and reliability of her claim. When this case is cited in combination with cases like R versus Ewanchuk, which set a near impossible to overcome consent precedent, and Faryna versus Chorny, which is a civil case curiously used in criminal courts that reduces the burden of proof beyond a reasonable doubt down to a balance of probabilities, and inserted into the framework of an ideologically biased judgment, it makes it all the more easier to convict an innocent man. One last thing about this case that I must point out is the fact that it wasn't even truly about a recent complaint, rather the admissibility of an expert witness. Yet, time and time again, I see this same part of this paragraph 65 inserted into other judgments. So this makes it clear to me that cherry-picking is the favorite pastime even for ideologically biased judges to find a most likely innocent man guilty.